Austin owns that the doctrine here laid down by him is inconsistent with the language used by writers who have treated of the British Constitution. It is further absolutely inconsistent with the validity of the Septennial Act. Nothing is more certain than that no English judge ever conceded, or under the present Constitution can concede, that Parliament is in any legal sense a trustee for the electors. Of such a feigned trust the courts know nothing. The plain truth is that as a matter of law, Parliament is the sovereign power in the state, and that the supposition, treated by Austin as inaccurate, is the correct statement of a legal fact which forms the basis of our whole legislative and judicial system. It is, however, equally true that in a political sense the electors are the most important part of, we may even say are actually, the sovereign power, since their will is under the present Constitution sure to obtain ultimate obedience. The language, therefore, of Austin is as correct in regard to political sovereignty as it is erroneous in regard to what we may term legal sovereignty. The electors are a part of, and the predominant part of, the politically sovereign power, but the legally sovereign power is assuredly, as maintained by all the best writers on the Constitution, nothing but Parliament. It may be conjectured that the error of which, from a lawyer's point of view, Austin has been guilty arises from his feeling, as every person must feel who is not the slave to mere words, that Parliament is, as already pointed out, nothing like an omnipotent body, but that its powers are practically limited in more ways than one. And this limitation Austin expresses, not very happily, by saying that the members of the House of Commons are subject to a trust imposed upon them by the electors. This, however, leads us to our second difficulty, namely the coexistence of parliamentary sovereignty with the fact of actual limitations on the power of Parliament. As to the actual limitations on the sovereign power of Parliament, the actual exercise of authority by any sovereign whatever, and notably by Parliament, is bounded or controlled by two limitations. Of these, the one is an external, the other is an internal limitation. The external limit to the real power of a sovereign consists in the possibility or certainty that his subjects, or a large number of them, will disobey or resist his laws. This limitation exists even under the most despotic monarchies. A Roman emperor or a French king during the middle of the 18th century was, as is the Russian Tsar at the present day, in strictness a sovereign in the legal sense of that term. He had absolute legislative authority. Any law made by him was binding, and there was no power in the empire or kingdom which could annul such law. It may also be true, though here we are passing from the legal to the political sense of sovereignty, that the will of an absolute monarch is in general obeyed by the bulk of his subjects. But it would be an error to suppose that the most absolute ruler who ever existed could in reality make or change every law at his pleasure. That this must be so results from considerations which were long ago pointed out by Hume. Force, he teaches, is in one sense always on the side of the governed, and government therefore in a sense always depends upon opinion. He writes, quote, "Nothing appears more surprising to those who consider human affairs with a philosophical eye than the easiness with which the many are governed by the few, and the implicit submission with which men resign their own sentiments and passions to those of their rulers. When we inquire by what means this wonder is effected, we shall find that, as force is always on the side of the governors have nothing to support them but opinion. It is therefore on opinion only that government is founded, and this maxim extends to the most despotic and most military governments, as well as to the most free and most popular. The Sultan of Egypt or the Emperor of Rome might drive his harmless subjects like brute beasts against their sentiments and inclination, but he must at least have led his Mamluks or Praetorian bands like men by their opinion." End quote. The authority, that is to say, even of a despot, depends upon the readiness of his subjects or of some portion of his subjects to obey his behests, and this readiness to obey must always be in reality limited. This is shown by the most notorious facts of history. None of the early Caesars could at their pleasure have subverted the worship or fundamental institutions of the Roman world, and when Constantine carried through a religious revolution, his success was due to the sympathy of a large part of his subjects. The Sultan could not abolish Mohammedanism. Louis XIV, at the height of his power, could revoke the Edict of Nantes, but he would have found it impossible to establish the supremacy of Protestantism, and for the same reason which prevented James II from establishing the supremacy of Roman Catholicism. The one king was in the strict sense despotic, the other was as powerful as any English monarch, but the might of each was limited by the certainty of popular disobedience or opposition. The unwillingness of subjects to obey may have reference not only to great changes but even to small matters. The French National Assembly of 1871 was emphatically the sovereign power in France. The majority of its members were, it is said, prepared for a monarchical restoration, but they were not prepared to restore the white flag. The army which would have acquiesced in the return of the Bourbons would not, it was anticipated, tolerate the sight of an anti-revolutionary symbol. The chasubles would go off of themselves. Here we see the precise limits to the exercise of legal sovereignty, and what is true of the power of a despot or of the authority of a constituent assembly is especially true of the sovereignty of Parliament. It is limited on every side by the possibility of popular resistance. Parliament might legally establish an episcopal church in Scotland. Parliament might legally tax the colonies. Parliament might, without any breach of law, change the succession to the throne or abolish the monarchy. But everyone knows that in the present state of the world, the British Parliament will do none of these things. In each case, widespread resistance would result from legislation which, though legally valid, is in fact beyond the stretch of parliamentary power. Nay, more than this, there are things which Parliament has done in other times, and done successfully, which a modern Parliament would not venture to repeat. Parliament would not at the present day prolong by law the duration of an existing House of Commons. Parliament would not without great hesitation deprive of their votes large classes of parliamentary electors, and, speaking generally, Parliament would not embark on a course of reactionary legislation. Persons who honestly blame Catholic emancipation and lament the disestablishment of the Irish Church do not dream that Parliament could repeal the statutes of 1829 or of 1869. These examples from among a score are enough to show the extent to which the theoretically boundless sovereignty of Parliament is curtailed by the external limit to its exercise. The internal limit to the exercise of sovereignty arises from the nature of the sovereign power itself. Even a despot exercises his powers in accordance with his character, which is itself moulded by the circumstances under which he lives, including under that head the moral feelings of the time and the society to which he belongs. The Sultan could not, if he would, change the religion of the Mohammedan world, but if he could do so, it is in the very highest degree improbable that the head of Mohammedanism should wish to overthrow the religion of Muhammad. The internal check on the exercise of the Sultan's power is at least as strong as the external limitation. People sometimes ask the idle question why the Pope does not introduce this or that reform. The true answer is that a revolutionist is not the kind of man who becomes a Pope, and that the man who becomes a Pope has no wish to be a revolutionist. Louis XIV could not in all probability have established Protestantism as the national religion of France, but to imagine Louis XIV as wishing to carry out a Protestant Reformation is nothing short of imagining him to have been a being quite unlike the Grand Monarque. Here again, the internal check works together with the external check, and the influence of the internal limitation is as great in the case of a parliamentary sovereign as of any other. Perhaps it is greater. Parliament could not prudently tax the colonies, but it is hardly conceivable that a modern Parliament, with the history of the 18th century before its eyes, should wish to tax the colonies. The combined influence both of the external and of the internal limitation on legislative sovereignty is admirably stated in Leslie Stephen's Science of Ethics, whose chapter on Law and Custom contains one of the best statements to be met with of the limits placed by the nature of things on the theoretical omnipotence of sovereign legislatures. Quote, "Lawyers are apt to speak as though the legislature were omnipotent, as they do not require to go beyond its decisions. It is, of course, omnipotent in the sense that it can make whatever laws it pleases, inasmuch as a law means any rule which has been made by the legislature. But from the scientific point of view, the power of the legislature is, of course, strictly limited. It is limited, so to speak, both from within and from without. From within, because the legislature is the product of a certain social condition, and determined by whatever determines the society, and from without, because the power of imposing laws is dependent upon the instinct of subordination, which is itself limited. If a legislature decided that all blue-eyed babies should be murdered, the preservation of blue-eyed babies would be illegal. But legislators must go mad before they could pass such a law, and subjects be idiotic before they could submit to it." End quote. Though sovereign power is bounded by an external and an internal limit, neither boundary is very definitely marked, nor need the two precisely coincide. A sovereign may wish to do many things which he either cannot do at all, or can only do at great risk of serious resistance, and it is on many accounts worth observation that the exact point at which the external limitation begins to operate, that is, the point at which subjects will offer serious or insuperable resistance to the commands of a ruler whom they generally obey, is never fixed with precision. It would be rash of the Imperial Parliament to abolish the Scotch law courts and assimilate the law of Scotland to that of England, but no one can feel sure at what point Scotch resistance to such a change would become serious. Before the War of Secession, the sovereign power of the United States could not have abolished slavery without provoking a civil war. After the War of Secession, the sovereign power abolished slavery and conferred the electoral franchise upon the blacks without exciting actual resistance. In reference to the relation between the external and the internal limit to sovereignty, representative government presents a noteworthy peculiarity. It is this: the aim and effect of such government is to produce a coincidence, or at any rate diminish the divergence, between the external and the internal limitations on the exercise of sovereign power. Frederick the Great may have wished to introduce, and may in fact have introduced, changes or reforms opposed to the wishes of his subjects. Louis Napoleon certainly began a policy of free trade which would not be tolerated by an assembly which truly represented French opinion. In these instances, neither monarch reached the external limit to his sovereign power, but it might very well have happened that he might have reached it, and have thereby provoked serious resistance on the part of his subjects. There might, in short, have arisen a divergence between the internal and the external check. The existence of such a divergence, or in other words of a difference between the permanent wishes of the sovereign, or rather of the king who then constituted a predominant part of the sovereign power, and the permanent wishes of the nation, is traceable in England throughout the whole period beginning with the accession of James I and ending with the Revolution of 1688. The remedy for this divergence was found in a transference of power from the Crown to the Houses of Parliament, and in placing on the throne rulers who from their position were induced to make their wishes coincide with the will of the nation expressed through the House of Commons. The difference between the will of the sovereign and the will of the nation was terminated by the foundation of a system of real representative government. Where a parliament truly represents the people, the divergence between the external and the internal limit to the exercise of sovereign power can hardly arise, or if it arises, must soon disappear. Speaking roughly, the permanent wishes of the representative portion of Parliament can hardly in the long run differ from the wishes of the English people, or at any rate of the electors. That which the majority of the House of Commons command, the majority of the English people usually desire. To prevent the divergence between the wishes of the sovereign and the wishes of subjects is in short the effect, and the only certain effect, of bona fide representative government. For our present purpose there is no need to determine whether this result be good or bad. An enlightened sovereign has more than once carried out reforms in advance of the wishes of his subjects. This is true both of sovereign kings and, though more rarely, of sovereign parliaments. But the sovereign who has done this, whether king or parliament, does not in reality represent his subjects. All that it is here necessary to insist upon is that the essential property of representative government is to produce coincidence between the wishes of the sovereign and the wishes of the subjects, to make, in short, the two limitations on the exercise of sovereignty absolutely coincident. This, which is true in its measure of all real representative government, applies with special truth to the English House of Commons. Burke writes, quote, "The House of Commons was supposed originally to be no part of the standing government of this country. It was considered as a control, issuing immediately from the people, and speedily to be resolved into the mass, from whence it arose. In this respect it was in the higher part of government what juries are in the lower, the capacity of a magistrate being transitory, and that of a citizen permanent. The latter capacity, it was hoped, would of course preponderate in all discussions, not only between the people and the standing authority of the Crown, but between the people and the fleeting authority of the House of Commons itself. It was hoped that, being of a middle nature between subject and government, they would feel with a more tender and a nearer interest everything that concerned the people, than the other remoter and more permanent parts of legislature. Whatever alterations time and the necessary accommodation of business may have introduced, this character can never be sustained, unless the House of Commons shall be made to bear some stamp of the actual disposition of the people at large. It would, among public misfortunes, be an evil more natural and tolerable that the House of Commons should be infected with every epidemical frenzy of the people, as this would indicate some consanguinity, some sympathy of nature with their constituents, than that they should in all cases be wholly untouched by the opinions and feelings of the people out of doors. By this want of sympathy they would cease to be a House of Commons." End quote. End of chapter 1.